Ms. Flowers, I think, has a question.
Yes, just for better understanding about adjudications of parentage, can you tell us the difference between presumed, acknowledged, and adjudicated fathers, just whether it's DNA or sworn statement?
Yes, a presumed father under Texas, under the family code, is someone who generally is the person who was married to the mother of the child at the time the child was born. So that person is presumed under the law to be the father of the child. That person that presumption can be overcome within a certain period of time by genetic testing if the person requests a genetic test. An acknowledged father is a person who established their paternity usually at the time the child was born by signing an acknowledgement of paternity. A lot of the hospitals encourage people to sign those if both parents are at the hospital and the person knows he's the father. That signing that acknowledgement creates basically a legal finding that that person is the father of the child. Now you can challenge that within a certain period of time. You can file a challenge to show either that you signed it based on fraud, duress, or material mistake of fact. And as long as you do that before there's a legal proceeding in the case with regard to the child, at that point you're within the time frame to challenge that. And then the judge, if they find that you've shown that either fraud, duress, or material mistake of fact, the judge will order a genetic test at that point. An adjudicated father just means a father that was adjudicated either basically by a court order that they were the father. Those are the ones that we do a lot of. You file a petition to establish paternity, and if the alleged father shows up, they can either say, yes, I'm the father, or they have the opportunity. We offer free genetic testing to parents and the child to determine whether or not they're the father. And then if they ask for that, then we go ahead and do the genetic testing and reset the court case. And when they come back to court, it's a little bit sometimes like those daytime talk shows where we have the results and you are the father or you're not. But that is what an adjudicated father is.
And all at no cost, that part, the testing.
Yeah, we don't charge for the first test. We used to require the non-custodial parent pay it back as part of the court costs, but we stopped doing that 7, 8, 9, 10 years ago, I think.
Okay, thank you.
Is an obligor at this time able to challenge paternity under certain circumstances? There
is a statute that was passed. I think it was probably in 2011 or 2009. I can't remember which one. It was a mistaken paternity. You can terminate the parental. If you file a petition with the court, you allege certain facts indicating that you mistakenly were adjudicated as the father. That point, the court can review to see whether you meet the threshold, order a genetic test, and then at that point, and it comes back showing that the person is not the father. The parental rights are terminated, but you still owe whatever was owed up to that point because you were the adjudicated father or you were the legal father of that child up to the point your rights were terminated.
So it stops any forward child support.
Yes, sir, it does.
But whatever you owed at that point, you're still responsible for.
Right, because essentially we can't really go after anyone else at that point because no judge is going to order that retroactive support against a person when someone else at the time was already adjudicated or by a court order to be the father of the child.
Is there a time limit for an obligor to do that?
Yes, the time limit is within 1 year. You have to file the termination suit within 1 year of discovering that you are not the father, or discovering that you didn't believe you were the father.
Okay.
So if you found that out and you wait 5 years and then do it, then the court at that point can dismiss the suit.
And is that the subject of dispute as to when you knew that?
We don't. I mean, as long as
For the most part.
we don't cross-examine a lot on that issue, unless the custodial parent is also there. If the custodial parent says he's known all along, he wasn't the father, since the child was born. Yeah, he signed those papers anyway. I mean, if there's obvious evidence of that, then we'll bring it before the court. But we're not there, so we don't. We have the distinct disadvantage of not having been involved in either of their relationships. So it's hard for us to prove one way or the other.